everyone. The last few weeks have been an incredibly hectic period for businesses, and for those of you who are working in HR or managing your business, I take my hat off to you at the moment. Now, the purpose of this quick video is just to give you the heads up on the latest employment law news without necessarily getting into a huge amount of detail. So rather it's just to give you the headlines, and I will follow up on the more important pieces of news in the next few weeks with some longer format webinars. So, what's been happening? And well, we can't get away from furlough, can we? So what we've seen, as you're probably all aware, is that the scheme has now been extended until the end of October. And this means that the government will have been funding this wages scheme for 8 months by the time it comes to an end. It's quite an extraordinary scheme and an amazing achievement to get a scheme like this up and running in such a short space of time, even if we do curse every time that they provide an update to the guidance late on a Friday evening. Now, as widely expected, from the 1st of August, employers will now have to contribute if they want to continue to access the scheme. So in August, this will be by paying the employer's national insurance contributions and pension contributions, which are currently covered by the scheme. Then in September, we'll see a further increase in the contribution that has to be made, up to 10% of the wages. And then again in October, we'll see a further increase, taking that up to 20%. So what that means in effect is that the government would then in October be funding 60% of someone's wages, and the employer will be funding the remaining 20% to then take it up to the continuing level of 80% with the cap at £2,500. That all remains the same. So this provides the tapering off to the scheme that was always intended, and it's hoped that it's going to provide that soft landing that the government keeps talking about for the economy and for businesses in general. But we'll have to wait and see to what extent the economy recovers over the next few months. But some good news for the government is that the current forecast on the cost of the scheme is that it's currently coming in at about a third less than they originally expected. So that's some good news anyway. And other further good news, certainly for employers in relation to the scheme, is that part-time work is now going to be possible. So you're probably fully aware of the very blunt tool that furlough was initially, in the respect that if somebody was on furlough, they couldn't do any work at all for you. But quite surprisingly, they were able to do work for a different employer. But anyway, that now ceases. So employees will be able, from the 1st of July, to be able to work part-time and be furloughed at the same time. And obviously then the split is then going to have to be worked out in terms of the wages. And employers are being given absolute discretion in relation to what that split should be. And so some people are referring to this as the flexible furlough scheme, but no sniggering about the acronym, please. Now, remember that it's only possible to furlough those people who were placed on furlough before the 10th of June, or should I say before or on the 10th of June. You cannot now put anyone on furlough for the very first time. Now, the one exception to this rule is in relation to those returning from periods of family leave, so most obviously from maternity leave. So on Wednesday of this week, on the 10th of June, the government announced that those who are returning to work from family-related leave will be exempted from this cut-off date. And so anyone returning to work following a period of maternity, paternity, adoption or shared parental or bereavement leave will be able to access the scheme, and access the scheme for the first time. So that 10th of June rule won't apply. So that's some good news for those people who are due to return to work in the next couple of months or so. Now, another coronavirus development that we've got that's passing through the regulations came on the 8th of June, where the regulations passed by the government in relation to a requirement for people to self-isolate in the UK when they return to the UK having travelled overseas. Now, as we entered into the holiday season, albeit that it's a very disrupted holiday season, but as we do enter that holiday season, it's quite clear that anyone who is then going abroad on holiday is going to have to self-isolate for 14 days when they return. Now, there's no provision in the regulations about how this period should be treated. And if someone can't work during this time, so that's clearly going to potentially give some issues for employers. So If they have to work from your site, this has a potentially significant impact. Of course, if they can work from home, then of course they can just continue to work from home during that period of self-isolation. So that's not so much of an issue. But what are employers going to do with employees who do have to work from the site? Can you say to employees that they should not go on holiday if they're travelling abroad? Or should you permit an additional period of leave after they return? Can they be furloughed when they return? Well, that's a possibility, but of course when you furlough someone, that's got to be for at least 3 weeks, which is clearly longer than the 14 days that they're having to self-isolate. So that depends upon whether that's something that you would want to do. And of course, they will have to have been previously furloughed, because if this is the first time that you'd be looking to furlough them, then we're still stuck with the cut-off date of the 10th of June. So then that doesn't work either. And there's no provision in the regulations in relation to statutory sick pay. So whereas other instances where somebody is required to self-isolate, then statutory sick pay kicks in, that's not the case in relation to this requirement to self-isolate. So it's something that we're going to need to start to consider as we approach the holiday season, as it appears increasingly possible that there are going to be some air bridges in place to enable these holidays to take place. So employers do need to have a think about what rules they are going to apply in relation to those people who are going on holiday and may be required to self-isolate when they get back. So, what other things are happening that you may have missed? Well, first of all, don't forget about the requirements relating to the written statements and main terms and conditions of employment. This changed from the 6th of April this year. So this is a result of the review into the gig economy that was undertaken as part of the Taylor Review. Now, this is now the perfect time to review your employment contracts. So it's time to have a think of the compliance with these new rules, which require your contracts to have a bit more information, whilst also considering perhaps as we enter into this new phase of working and new ways of working, about the introduction of home working clauses, flexibility clauses, and perhaps the post-termination restrictions that we addressed in one of our earlier sessions. Our video on post-termination restrictions is still available, so please do go and view it. And finally, an interesting redundancy case. This is of course particularly relevant given the issues that many employers are facing at the moment and the significant increase that we are seeing in the redundancy process. And the case is Gwynedd Council and Barratt. Now, very briefly, Mr. Barratt was one of 2 PE teachers who were made redundant when their school closed. And the closure was as a result of a reorganisation into one much larger school. Mr. Barratt and his colleague were not considered for any of the new PE roles at the new school, and clearly that's unfair. However, putting that obvious unfairness to one side, what this case did go on to do was to provide us with some further guidance on when employers can and should use a forward-looking recruitment process, or when it should rely on the redundancy selection process. So this is the whole issue of, are you selecting out through a selection criteria, or are you selecting in through a recruitment process? Often employers do like to use the forward-looking recruitment process because it permits a slightly more subjective approach and allows a bit more structure around the future needs, around the forward-looking needs of the business, rather than a historical look at performance in the past. And the principles of this way of undertaking a redundancy selection was set out in the case of Morgan and the Welsh Rugby Union. Often this then also results in an employer moving away from the traditional redundancy consultation process, as was the case here in Barratt. Now, the key point to take from this case is the narrowing of the application of Morgan. What Barratt says is that where recruitment is to the same or substantially the same role as the one which they were doing before, then an assessment through the use of forward-looking recruitment criteria is likely to be unfair. Rather, employers should use something closer to a selection criteria from within a pool. So your standard sort of redundancy selection criteria, that's what you should be looking at. So be careful in the design of the process surrounding restructures that you might be undertaking at the moment as part of the steps to reduce costs as a consequence of the coronavirus situation. So, what's coming next? Well, first of all, we're going to be delivering a full employment law update session on Wednesday the 8th of July. That's going to be by webinar again, and then over the next few weeks, I should say, not shortly after that, but over the next few weeks, we're then going to be developing some short webinars that you can use as quick revision tools for your line managers. So our first tool will be absence management. So this is going to provide a summary of the main points that line managers must ensure they have addressed when managing the absence of those that report to them. There'll be separate short sessions for the management of both short and long-term absence. And then once we've published our absence tool, we'll then publish further tools on performance, investigations, and also disciplinary hearings. And we'll, of course, let you know as soon as these are ready. If you're an existing retainer client, you'll obviously receive free access to these tools. If you're not currently a client, there may be a charge for these. Of course, if you'd like some information on our advice, tribunal or training packages, or simply want to get in touch on an ad hoc basis, then do just drop me an email or give me a call. That's all. Hope to speak to some of you soon. Take care. Thank you.